session. We have with us Shri Anil Goel sir and Miss Pooja Bahry ma'am. They will be taking up the session on liquidation case laws. And Pooja Bahry ma'am, you can start the session. Thank you.
Thank you. Good afternoon, everyone. Good evening, everyone. And I welcome you to this panel discussion. And I will be taking up 4 very important case laws with respect to liquidation. And then Mr. Goel will be taking up some about, I think, 4 or 5 again case laws. And then we can then in the end have discussions on if there are any questions and, so that we can also, take everyone's views in the process. And every day, in fact, liquidation is a process which has evolved and has had the maximum number of amendments since the IBC actually came into force. Since 2016, liquidation process the regulations have amended many times. And finally, now the jurisprudence for the same has developed to an extent that we can say that a lot of matters are being closed. And but of course, there are many, many questions which are still left when we talk about the liquidation process. So I will be taking up primarily 4 case laws, 2 with respect to a matter of mine, which was about the capital gain tax issue. The second I would be taking up about the dissolution is not allowed by an order of the NCLT till there are pending investigations. That's again another matter of mine. Then we'll be discussing sale as a going concern with respect to the Mohan Gems case, which in the NCLT and then in the NCLAT. And finally, the latest judgment, which I will be discussing, is in the matter of Mr. Navjeet Singh, which is State Bank of India, wherein this was regarding the liquidation process fees. So this order, I think, came on the 16th of March 2022 only, a few days back. So we'll be discussing that. So I will be discussing these 4 case laws with you in the coming 15-20 minutes, about, let's say, half an hour. So to begin with, one of the first case laws which I like to discuss is regarding my matter only, which is about, and I hope everyone can see the full screen. My presentation is wanted.
Yes, ma'am.
Right.
Yes, ma'am.
So one of the first, it is one of the earliest orders which had happened in 2019, but it did close quite a few issues, primarily about the capital gain tax issue. So in fact, in one of my earliest cases or as a liquidator, so there was a lack of clarity regarding payment of capital gain taxes, and especially with reference to, if there was sale of secured assets by a liquidator. And truthfully, it was the early days in IBC. And it was very important to decide the question of law, to decide the question of priorities, that will capital gain tax be a liquidation cost, or will it have to be distributed as per Section 53? Because the income tax department, as per the income tax department and various judgments which were there, capital gain tax was to be considered as a liquidation cost. And if it was considered as a liquidation cost, because it is something which is has arisen during the liquidation process. So then in that way, about approximately 20% of whatever has been the realization of any liquidator would have directly gone to the income tax department and not as per Section 53. So this was an application. Yes, sir.
You had discussed it last time also, no?
Yeah, I don't know. So this is the first time. I mean, otherwise I give a lot of sessions on liquidation.
Okay.
So when I'm giving my sessions on liquidation, I think there are 3-4 case laws which I always discuss, and because they have been important ones. So today was only about the important case laws in liquidation. So that's the reason I'm taking it up right now. So primarily now capital gain tax is, as you know, if there is any sale proceed which has been done by a secured creditor, by a secured financial creditor who has particularly relinquished his security interest. So in that case, the capital gain tax, is it to be, where is it to come under Section 53? So I had asked the court to pass an order whether this tax is to be paid on the sale proceeds from the sale of the secured assets, and in case the same is to be paid, then the category at which the same is to be treated as in the distribution waterfall as per Section 53. So finally, the order in this was passed, and that it was finally ordered that capital gain tax would be an operational debt. It would not be a liquidation cost. And also the NCLT had held that any capital gain tax liability which is arising out of the sale will be distributed only as per section 53 of the code. And the only important part which we as a liquidator which we need to know is that any tax liability which arises out of this sale will be distributed as per section 53, and the applicability of section 178 or 194 IE of the Income Tax Act will not have an overriding effect on the waterfall mechanism, which is a complete code in itself, and the capital gain tax would not be considered as a liquidation cost. This was primarily important because otherwise, if such a judgment had not been there, then no secured creditor would actually have relinquished their security interest to a liquidator. Because if they had utilize the provisions of SARFAESI Act, because as a secured creditor, they do have the option to utilize SARFAESI Act also and, realize their assets, then in that case, they would not have to pay that 20% of as a capital gain tax. So that's why the closure of this issue was extremely important. So next, this is the first judgment I wanted to discuss. Another judgment is regarding completion of liquidation, about dissolution. I'm sure this is also something, I think almost everybody would know about this particular matter. Now, as you know what the regulations say. The regulations say that the liquidation needs to be completed within a period of 1 year. And of course, additional 90 days can be taken if it is sale as a going concern. But what happens when there are applications for avoidance which may be pending? What happens if the applications for avoidance are over, but then there are other investigations which are going on? And though the code says that the liquidator shall liquidate within the period of 1 year, and it also says that it's notwithstanding the pendency of any application for avoidance of any transactions, but the jurisprudence which is actually formed now over the years is that yes, the order which has actually come by the court is that investigation does bar dissolution of a corporate debtor. So as per this, there was, I'll give you a brief background in 5 minutes of my matter. So primarily in this case, I was the RP. Again, G Ispat had filed an application for avoidance, for fraud, for falsification and books of account, etc., because of fake debtors. And the NCLT had passed an order in 2019 that's saying that we order that the affairs of the corporate debtor ought to be investigated. And accordingly, they directed the central government to order an investigation into the affairs of the corporate debtor. Against this, the corporate debtor, the directors, in fact, the ex-directors, they went in appeal. And finally, various, in appeal in the NCLAT, after various dates, the order had actually come that they referred the matter to the Secretary of Ministry of Corporate Affairs to carry out an investigation by the inspector, following which the due process as per law would be done. And if the matter needs to be examined by SFIO, then the central government, and if they feel that the fraud is made out, then again, SFIO would continue the investigation. Now, this is something which happened in 2019. Now, finally, this is 1920, and in the meantime, I had realized the assets of the corporate debtor. So what were the available assets? I had done the realization, I had done the distribution, and as of March 2020, my liquidation was over, almost over, as in because this is an application which was an investigation which was pending, for which and the MCA had not even issued the notice, had not even started the investigation. So when I filed the application for dissolution of the corporate debtor, because as per the provisions of the code, at that point of time, the liquidation had to be over in 2 years. Now it is 1 year. So there was detailed discussions. There were detailed discussions on whether the pendency of any investigation, would it create a bar for passing an order of dissolution. So finally, the adjudicating authority held that yes, dissolution will put an end to the legal existence of a company. And once a company is dissolved, it becomes a non-existent party. So therefore, no action can actually be brought about in its name. It was also discussed that a liquidator will not be able to represent this non-existent corporate debtor before any of the investigating forums. So, and in case it was held by the court that in case any recovery is affected, or if any asset is recovered through investigation, the same needs to be vested in the corporate debtor, because as you know, as it would be a part of a liquidation estate. Any money which comes in from avoidance becomes a part of the liquidation estate. And the court held that if the corporate debtor is dissolved, then the dissolved status of the corporate debtor will create an impediment in vesting these assets and benefits to the corporate debtor. So finally, the court was of the opinion that yes, Section 54 makes it mandatory for the liquidator to make an application for dissolution. However, because of the investigation, it is ordered by the NCLAT. In this case, it creates a possibility of infusion of more assets into the corporate debtor on completion of this investigation, which will be required to be liquidated among the stakeholders. They also said, they made it clear, the NCLT made it clear that yes, Regulation 44 says that the liquidator has to mandatorily liquidate the corporate debtor within 1 year, irrespective of pendency of an application for avoidance. However, they also said that there is nothing stipulated in this regulation which binds the adjudicating authority to order dissolution. So finally, the order which came about was that yes, in order to facilitate completion of investigation for maximization of assets and to ensure smooth distribution of the proceeds arising out of this investigation among stakeholders, judicial proprietary demands that the corporate debtor should not be dissolved at this stage when the investigation as ordered by the NCLAT is pending. So we are of the opinion that the pendency of any investigation, it creates a bar in ordering dissolution of the company. And of course, they asked the Ministry of Corporate Affairs to expedite the investigation, which was ordered in the NCLAT order. So there, in fact, over the years, I have had a lot of queries regarding and there have been not one, but many other cases also, wherein similarly, because of the pending investigations, the court has not ordered dissolution. So this is a matter which needs to be, I think, somewhere or the other closed, that who is the one who is going to be pursuing such an application, who is going to pursue the investigation further on. And yes, in fact, this is one of the discussions which we've been having where some amendments need to be made in the court, because as a liquidator, you and I, we are liquidators, and wherein we will be, there are cases where the liquidation would carry on for a number of years. So being for a number of years, I mean, it's like for me, it started in 2018. So from 2018 to I'm in 2022. So there are a lot of things, there are a lot of compliances which the liquidator has to continue to do, despite the fact that the main liquidation, that is for selling the assets and distributing among the stakeholders, is over. So this is one case law, wherein regarding dissolution, which is because of pending investigations, no dissolution was allowed by the court. The next case law, which I would like to discuss, is about the Mohan Gems matter. Now, as you all know, when we talk about the manner of sale, now selling the corporate debtor as a going concern, or selling the business of the corporate debtor as a going concern, is one of the manners of sale, which is given in Regulations 32. And of course, where an asset is subject to this security interest, till the interest is relinquished, the liquidator cannot sell under these clauses. Now, since the beginning, the manner of sale has remained the same. Selling the corporate debtor as a going concern and the business of the corporate debtor as a going concern has always been there. But practically, there were very, very few matters wherein sale as a going concern was actually happening. So again, when the amendments were made, the Regulation 39C had been added at that point of time, wherein, when you're approving a plan or you're deciding to liquidate the corporate debtor, then yes, the COC may recommend that the liquidator can first explore corporate debtor, the sale of the corporate debtor is a going concern. So this was a new regulation which had been added, Regulation 39C. And a corresponding 32A in the liquidation regulations was added, that yes, where the committee of creditors is of the opinion that sale as a going concern should happen, or if the liquidators of the opinion or the COC is recommended, then in that case, sale as a going concern would first be, the liquidator will first endeavor to sell under the said clauses. And of course, it was also mentioned that if he's unable to sell in 90 days, then he will use the other, other proceeds like clauses A to D of regulation 3932. Now, but when the Mohan Gems judgment came, so there was an order in the matter of Mohan Gems. So there was one case wherein Mohan Gems and Jewels, where the NCLT principal bench in 16 September 2020, basically the Mohan Gems matter was, in fact, this was a corporate debtor. It was sold as a going concern. But in that case, the adjudicating authority had dismissed the application for closure of liquidation, saying that Section 54 requires dissolution, whereas the corporate debtor is not dissolved in sale as a going concern. So it was a lot was said in that particular order, wherein they said that the IBBI regulations are beyond the IBBI powers, and they also said that the mandate of Section 54 is to terminate the life of the corporate debtor by dissolving them after liquidation. And against this, IBBI had passed these regulations directing dispensation of the operations of the Section 54 by devising a concept which is not present in the code itself. And finally, only where you can close the liquidation process. So finally, and this judgment was there for a long period of time. And in fact, it was mentioned in the order that, if it is selling of the business of the corporate debtor, we may not call upon the scrutiny of the regulations because business is going to remain tied up with the undertaking. So primarily, they said that selling of a company is not envisaged under IBC, and it is unknown to law and beyond the discretion given to IBBI. So all that was said. And primarily, they said that sale as a going concern cannot happen. Then they also, it was very clearly mentioned in that judgment that, the wisdom of the parliament and the jurisprudence developed over centuries cannot be wiped out by a regulation. That it looks good to the eyes, that you say that you're selling it on a going concern, but it is not in the hands of either this authority or the IBBI. So they felt that the tribunal is not conferred with the power to deal with any issue which is falling under, this particular code. And accordingly, they dismissed the application for sale as a going concern. Finally, the matter went to NCLAT, and in August 2021, which is 24th of August 2021. So finally, the order came in this matter, and wherein the challenge was to that impugned order of the NCLT, for which had dismissed the application seeking closure of the liquidation process. Now, primarily in detail, the NCLAT went into whether the liquidator can sell as a going concern, whether the adjudicating authority was correct in concluding that the regulation 39C and 32A are inconsistent with Section 53 of the code, and also detailed order was passed whether the interpretation of the liquidation process regulations is contrary to the scope and spirit of the IBC. So accordingly, finally the NCLAT answered these issues regarding the powers of the liquidator, and they allowed the appeal, and they held that yes, that it is well settled that the legality, propriety of any regulation notification cannot be looked into by the NCLT or the NCLAT. So they also, they finally held, they answered the issues regarding the power of the liquidator, and they said that the NCLT has, apart from traveling beyond its jurisdiction in making observations regarding the powers and functioning of IBBI, they have not appreciated what is the ratio which was laid out by the Supreme Court in the various Katanow judgments and the liquidation of the company, that as a going concern. So finally, they gave an order that any order of dissolution is completely unnecessary in such a case. And they also held that yes, a closure report be filed as as per Regulation 45. And it would be contradictory to observe that closure of a liquidation cannot be done and only dissolution is provided under the code, because that would demolish the very spirit and the very objective of the code. So finally, they said that if no decision is taken as per Regulation 39C by the COC, then only Regulation 30A2A is to be followed. And they also said that the question where the COC has not passed any resolution, so we feel that the liquidator has in that case followed the right procedure, which is given as per Regulation 32A of the liquidation process regulations. So finally, this matter was closed. Thereafter, various judgments had come, wherein sale as a going concern was allowed. There was a judgment of Gaurav Jain versus Sanjay Gupta, which was liquidator of Topworth, wherein they said that the sale is transfer of assets along with the liabilities, but in a liquidation there is a clear difference that only assets are transferred and the liabilities of the corporate debtor would be settled in accordance with Section 53. And it was held that the corporate debtor will not be dissolved as per Section 54, and the assets with the claims, limitations, licenses, they remain in the company. Again, two very important judgments I remember were shared by IBBI also at that point of time. This was in 2021 only, June 2021. One was Shrey Equipment Finance versus Vishwa Infrastructures Finance and Services Limited. In that also, the successful bidder had given a term sheet that these are the reliefs and concessions which were discussed in the stakeholders committee meeting. It was mentioned that the fund will be utilized by the liquidator for disbursement only on approval of the term sheet by the tribunal. And it was also almost like a resolution. It was a resolution of the corporate debtor, and the reliefs which were mentioned were allowed by the adjudicating authority. Again, and another matter of Elcon Engineering versus Enviro Bulk Handling Systems. Similarly, the successful bidder had filed an IA which was seeking various reliefs, concessions, and those reliefs were allowed to the extent that was mentioned. So here I complete the third, judgment, which was about sale as a going concern. Now the fourth is, I think it's a new judgment which has come about 4-5 days earlier only, and in the NCLAT. So this is actually in the matter of GRS Ispat Company Private Limited. So in this case, there was an order. This primarily was regarding whether in liquidation, if there is a secured creditor, and will he have to pay the fees to the liquidator, even where he has decided to sell the assets separately and not has decided not to relinquish to the liquidation estate. So before we discuss this judgment, as in GRS Ispat, and what is the appeal which had been filed, and which is recently on 16th March 2022, this order has come. So just in brief, in 5 minutes, I'll just speak to you about what are the provisions with respect to which we are going to be discussing in this particular judgment. So of course, the first provision is about the liquidator fees, wherein the COC decides what is the fees which is payable to a liquidator when they are deciding to liquidate the corporate debtor, or where they are deciding to approve a resolution plan. So if the fees is not decided by the COC, then there is a Regulation 4 in which the liquidation regulations are given, wherein it is mentioned that the fees of the liquidator will be as per the decision taken by the Committee of Creditors as per Regulation 39D. And if it is not taken, then there are provisions which are given that the liquidator will be paid at the same fees as RP, or if there's a compromise arrangement, or otherwise he'll be given as a percentage of the amount recovered net of liquidation costs. So there is this kind of table which is given, which says that if the COC does not decide the liquidator's fees, then it will be paid as per these regulations. Again, an amendment had come in the liquidation regulations, wherein a clarity had been given. And that clarity was that where a liquidator has realized any amount, but he does not distribute it, he will be entitled to a fees corresponding to the amount realized by him. And where a liquidator distributes any amount which is not realized by him, he will be entitled to a fees which is corresponding to the amount distributed by him. So this was an amendment which had been made in the liquidation regulations. And on your screen right now, you can see what all is included in liquidation costs. So among the various factors which are included in the liquidation cost, so one of them is a fees which is payable to the liquidator under Regulation 4. So again, there were additions which were made, which was about contribution to the liquidation cost. While approving a plan, they may make a best estimate, what would be the liquidation cost, what would be the liquid assets, and then they would be finally contributing. There's a Regulation 2A which has been given. So this is what is being discussed in this particular order, which we'll be discussing, that the committee of creditors, if they do not approve a plan, then the liquidator will call upon the financial creditors to contribute the excess of the liquidation costs over the liquid assets. And there is a table which has also been given. And there another amendment which had been made in the liquidation was presumption of security interest, which is given in Regulation 21A. So as per this, if there is a secured creditor, he will have to inform the liquidator that is he relinquishing to the liquidation estate, and if he's not relinquishing to the liquidation estate, then and if he hasn't informed by the first 30 days, it'll be presumed to be a part of the liquidation estate. So this particular order had come. This is another case in which this order had recently come. This was in Technofab Manufacturing, wherein the liquidator, I think Mr. Goel will be doing that case in detail. If not, then I'll discuss in the end. So one important, wherein it is mentioned that about the liquidation, now about the fees. Now, when we discuss the fees, now we come to GRS's part, which we need to discuss, wherein there was a case where there was no claim from a workman. As per Regulation 21A, the applicant is obligated to make payment of liquidation costs only and not the fees as claimed. So what had happened in this case, that the as by the perusal of the provisions, it indicated that there is a secured creditor. He said that I am liable to pay the liquidation costs and fees in full, but wherein in respect of a liquidator's fees, he said that I am realizing the assets on my own, and thus the liquidator is not entitled to the fees. So in respect of this liquidator's fees, it was submitted that the liquidation fees is only payable on the percentage of the amount realized and on the amount distributed. And here, since the secured creditor is realizing his security interest on his own, and the liquidator will not get any fees. So basically, they agreed that yes, we will pay the costs in liquidation, but not the fees to the liquidator, because we are realizing on our own. So in that case, the NCLT held that where there is a secured creditor, he realizes his security interest, he shall pay the liquidation costs, which includes the liquidator's fees. So as I just showed to you, one of the part of the liquidation costs is the liquidator's fees. They also mentioned the new provision which has come, that where a liquidator distributes any amount which is not realized by him, he shall be entitled to a fees which is corresponding to the amount distributed by him. So accordingly, they said that as a respondent has not given any objections in allowing the application or in compliance of the regulations, we dispose of the application. We direct to make payment of the liquidator's fees and ensure compliance of Regulation 2A AEA, Regulation 2A, Regulation 21A, and Regulation 37 of the liquidation regulations, and Section 52, 53 of the code, and act as per provisions of law. So primarily it was held that yes, the liquidator's fees will also have to be paid by that secured creditor who is realizing on his own. So finally that matter went to the NCLAT, and now on the 16th of March 2022, the matter was finally adjudicated upon, and the NCLAT held, they said that the adjudicating authority has only referred to the regulations. The adjudicating authority has said Regulation 2A EA, Regulation 2A, Regulation 21A, and 37 of the liquidation regulations. So they have said that we dispose of the application to make the payment of the fees and ensure compliance of these particular regulations with respect to the liquidator's fees. The liquidator had submitted that even if the securities which are out of the liquidation process, the appellant is liable to pay the fees as per Regulation 21A as well as Regulation 2EA of the liquidation regulations. So insofar as the liquidator's fees is concerned, so basically they had, the directions were given that to make the payment of the liquidator's fees and to ensure compliance of Regulation 2 and Regulation 2A, 21A and 37. So the NCLAT held that the order which is passed by the adjudicating authority does not warrant any interference. And they said it is clear that even if a secured creditor proceeds to realize his security interest, it is liable to pay the fees as contemplated under Regulation 21A and Regulation 2AE. So this is, to understand this particular order, we need to understand these particular regulations. So as per the understanding that yes, the liquidator is eligible to get fees even in those matters, wherein the secured creditor has realized on its own, and they said that we will only pay the workman dues and only the costs. But the court held that yes, even if it is mentioned in the regulations only that any amount which is distributed but not realized, he will be entitled to a fees which is corresponding to the amount distributed by him. So I conclude these four cases wherein, where I've done my discussion. So I think now Mr. Anil Goel can carry on, his for some. Yes, sir.
Hello. First of all, we must say thanks to you, ma'am. All the four cases were very good.
Thank you very much, sir. Thank you so very much, sir.
Hello.
Yes, sir. Can you see?
Yes, madam. My question is that I see your presentation and solution of cases. In the one and four, you say your first cases and fourth cases.
Yes,
you said me if there is a capital gain tax.
Yes, sir.
When you are selling the property.
Yes,
and
sir.
court is considered that is a operational creditor. Okay.
Yes, sir. Yes.
I see your 3 or 4 cases, and I come to the conclusion in my understanding, these cases should not go to the court also.
No, sir. I will really. Yes, sir.
One second. Let me finish. First, and I'm just seeing your first case and last case. Okay. In first case, if there is a capital gain tax, so we are selling something, there is a capital gain. So ultimately, the operational creditor, it will go to the as a operational creditor, you have to pay and going to go to the government. Okay. And so many cases, I think that which should not go to the court, it is also going to the court. And in last case, madam, if you see, if the secured creditor is saying that I am not I will not pay the liquidation fees because I am handling all these things. But second question is that if the secured creditor is not able to satisfy his full claim, then his which will be the remaining of the claim will go to the as per waterfalls mechanism.
I didn't understand, sir, what you're trying to say. No. See, I'll tell you. When we come to, let's go case by case. So you said that the first case and the last case should not have gone to the court. Sir, today we are talking, we are in 2022. We have to appreciate that the first case was in 2018-19. That is a matter wherein, as a liquidator, there are cases, there are a lot of assets where you need to appreciate, wherein the assets are already charged to a secured creditor. Let's say they're charged to 2 or 3 secured creditors. And there are cases where there are huge blocks of land, okay, which had been bought at a very, very low value. Let's say in my matter itself, I think it was bought for a value of 50 lakh rupees, that particular land. And as a liquidator, when I sell, I am selling on behalf of the corporate debtor. Please understand that. When the secured creditor takes possession of that particular asset and sells it under the SARFAESI Act, they are selling it as a secured creditor. So they are not liable to pay any capital gain tax on this. And if when I am selling it a 50 lakh asset, I sold at 8 crore rupees. So from that 8 crores minus 50 lakhs, approximately 20% of the same may have to be paid, and which will be beyond the section 53, sir. So there was a very much big clarity which was needed at that particular point of time, because this is one of the earliest cases, you have to understand. So this was the reason lot of secured creditors were not even relinquishing the security interest to the liquidator. They felt that why should we relinquish to the liquidator when we can sell the same asset which is secured to us under SARFAESI, and we would not have to take that. Anyways, they're taking a haircut. We would not have to take that additional 20% haircut. So as a liquidator, you and me, what would we have sold if there had not been anyone relinquishing their security interest? You need to understand, if a secured creditor does not relinquish, what do you, as a liquidator, what do you sell? What is your liquidation estate? What do you distribute? So that is a fact that this was very much needed at that particular point of time. And I mean, retrospectively, there has been a lot of jurisprudence which has been formed in these 5 years, which has got us the clarity today that we are able to take if you just pick up the initial regulations which had come of liquidation, they are very different. They are very different than what they are today. All these regulations have been amended over times, when even today I feel there would be quite a few amendments which would be coming. The second case that's I believe that is not my matter, but why Mr. Navjeet, why this is an appeal which had been filed by the secured creditor against the liquidator, that I will not pay the fees. So it's not that it went to the court by itself. It was filed by the financial creditor that they will not pay the fees on what has been sold what has been which is not a part of the liquidation, which is sold outside liquidation, that we will not pay fees. Yes, we will pay the cost, but we will not pay the fees. So it was, if you see the order, then that order is in the matter of State Bank of India versus Navjeet Singh. So though it is in that case of GRS Ispat, but actually it is SBI versus Navjeet Singh. Yes, sir.
Madam, in my case, despite this order, one of the secured creditors, which is ICICI Bank, is not paying either the liquidator cost or the liquidator fee.
Sir, I truly appreciate what you are saying. I am in the same boat. I mean, I may be discussing the cases with you, but believe me, I am very, very much in the same boat. And there are cases wherein, but at least when a jurisprudence is formed, I feel that we are able to, fight our case a little better. And we have some kind of order which we can show even when we are writing a letter to the secured creditor or to any stakeholder for that matter. So all the jurisprudence has been formed. The reason it is formed is not only because, it's for, of course, our knowledge, but it's also when we face such situations, we can quote these orders. And yes, if they do not still listen, then of course we again have the option of going to the court, but I always say go to the court as less as possible, less frequently as possible.
In my case, adjudicating authority is seized of the same matter for last 2 years.
Yes.
And still, despite
so now, so this is a new order which you can place before them as an additional document, which has recently come. So hopefully you may get favorable orders in your case, sir.
Thank you.
Thank you. I think over to Mr. Goel.
Thank you, Pooja. Thank you very much. I think it would be really nice. This audience is very interactive, and they would actually be asking a lot of questions, and it will really be nice. I think you have covered some very important judgments, and in fact, there are many unresolved issues in the liquidation process under IPC. I will be taking up some of the unresolved issues. Some of them are pending before Supreme Court, or some of them are pending with the NCLAT. But yes, these are all very, very important issues. First of all, I will take up all those issues which has been circulated by ICSI, IPA, and as Radhika has already circulated, that these are the cases that actually would be taken up. And also we would be discussing some allied kind of laws which are already there. So I'll just share my screen, and I'll try to find out because I have regulations also in front of me. So I will just do that. Some difficulty, and it is just
Sir, your screen is not visible now.
I think
Now it's
there's
visible.
something which was hanged over.
It's visible. It's visible now.
This is the, yeah, it is visible, and again it has gone off. Let me do it again. There's some problem with my internet just started because there was a power failure in between, and then I think this must have rebooted.
Sir, please continue from your end. No problem. It will come later.
No, I think this. Okay, see, can you hear me?
Yes, we can hear you.
Okay, so I think let me take up one subject which is related to the last discussions which was done by Pooja, and that is regarding the taxation on the sale of assets and also the tax deduction at source under Section 1 of the Income Tax Act. When we sell any of the assets and there is a deduction which is required, I think 1% of the total sale of assets if the consideration is more than 50 lakhs of rupees. So that is something which is like my internet connection is unstable. So let me come back again.
So you can speak because we were able to hear you.
So one, not this one, but then there is another case that I would like to discuss with you. That is the Om Prakash Agarwal, the liquidator of S. Kumar Nations. That is one case versus the Income Tax Department. In fact, the Commissioner of TDS. That's a case which is the latest as regards the tax treatment is concerned on sale of assets during liquidation process.
Your screen is showing Dhanpak Lakshmi.
Yeah, I'm luckily screen is showing Dhan Lakshmi, but then since this was being discussed by Pooja Bahry, so I would just continue with the same discussion. And one was that case which was discussed by Pooja, which is G Ispat, and in that case it was kind of held by NCLAT that the capital gain tax is not leviable on the sale of assets. But then the premise was different. The discussions in the order was different. However, in case you would see this order, Om Prakash Agarwal versus the Commissioner of TDS. So that was the case which was argued by me personally, and the argument was based on the Income Tax Act and as well as the regulations under the IBC for liquidating a company. So what was the argument? The argument was that in the liquidation process regulations, there is no requirement for preparing a financial statements for balance sheet, profit and loss account. There is no requirement. The only requirement under the liquidation process is that the liquidator has to prepare a receipt and payment account, and that receipt and payment account would be audited. That's the only requirement. It is also not provided anywhere that the liquidator will get the accounts audited or even tax audited. Then I went to the income tax provisions, and the income tax provisions are various provisions where it is discussed that what all is required to file an income tax return. So when we file an income tax return, it requires for a limited company, private limited company, or for a limited liability partnership, it is required that the financial statements of where the profit of the company can be ascertained
those are required. So for in the case of LLP and in the case of private limited or limited companies, it is also required to be audited. In case it exceeds a turnover, then it also requires to be tax audited. Then there are all these requirements are provided in the rules, and in case these requirements are not completed, then the return filed by the liquidator would be considered as invalid. So if a return is considered as invalid, then whatever tax at source is deducted by any of the buyer of the properties, that actually would not be refundable to the liquidator, because the liquidator cannot claim a refund without filing an income tax return. So the income tax provision says that the return cannot be filed in case these documents are not available. The liquidation process says that these documents are not required to be prepared by the liquidator. Tax is being deducted by the buyers under section 194I capital A. So therefore, there is a contradiction between income tax law and the IBC. Therefore, it was held by NCLAT that wherever there is a contravention between two laws under section 238 of the IBC would prevail. Therefore, if the tax returns is not required to be filed by the liquidator, even under section 179 of the Income Tax Act, the liquidator has got no authority to sign the income tax return. It is only the resolution professional or a voluntary liquidator or the official liquidator as appointed under the Companies Act, earlier Companies Act. However, in this liquidation process, the liquidator is not supposed to prepare all these and is not required to submit the income tax return. Therefore, it was held that the income tax is not supposed to be deducted at source by the buyers. So that was only a specific judgment on the section 194IA. However, it also is applicable to other. It is also applicable to the other TDS provisions. Suppose, as an illustration, in a company has some rental income during the liquidation process, or if a company is being kept as a going concern, then it might be argued separately, because see, when the company is kept as a going concern, it is almost akin to finding a resolution plan, and that somebody might argue differently. However, in case the company is being sold and the company is being liquidated, then in that case the TDS provisions are not applicable, and that particular order, in fact, till about 9 months from that order, the income tax department had not filed an appeal. But of course, of late, I've heard that the income tax department have filed an appeal, and we will argue that also now before the Supreme Court, because there is a contradiction between the IBC and Income Tax Act. So this is one scenario which is attached to the judgment of G. Ispat, where the capital gain tax is not applicable. That was held. So it is not simple. One of the participants was saying that these kind of subjects should not have gone to the adjudicating authorities or appellate authorities, but these clarities are very, very important. I still understand that many liquidators, they are preparing audited balance sheets, they are even filing the income tax returns during the liquidation processes, and that is something which is being done. However, the law and the NCLAT judgment doesn't say that way. Coming to the other judgment, which is Dhanalakshmi Bank Limited versus Techno Manufacturing Limited, and this particular judgment talks about the when section 52 is invoked by a secured creditor, then the secured creditor has taken the responsibility of selling the secured asset because of the exclusive charge, and in that manner the law also puts a responsibility on the secured creditor that everything would be done within a stipulated period as provided in regulation 21 of liquidation process regulations. Now in this case, it was a secured creditor, and the secured creditor wanted to realize its asset because of exclusive charge and invoked section 52, and the liquidator verified the security in trust. The liquidator, so the liquidator then the liquidator, okay, handed over the asset to the secured creditor, and that was done in September 2019. And they, later on, the first and second auctions of the secured asset were made on 3rd of September 2019 and 6th of January 2021 respectively. The liquidator had then asked the appellant to vacate the asset he was in physical possession and to return the asset back to the liquidation estate. Now, the case of the liquidator was that as per the regulation 21 capital A of the liquidation process, you are supposed to sell the assets, you are supposed to put all your efforts to realize the security interest, and it has to be done within a period of 6 months. It has to be done within a period of 6 months maximum. Originally, it is 3 months, but it can be extended by 180 days. Now, the sub-regulation 3 of regulation 21 provides that whereas secured creditors fail to comply with sub-regulation 2, the asset which is subject to security shall become part of the liquidation estate. Now, the liquidator says that the asset is now handed over to you for the last 3 years. It was handed over in September 2019, and the last auction that you did, which failed, is for January 21. So September 19 to September 21. So I think it is already more than 2 years. So therefore, the tribunal, the NCA adjudicating authority, passed an order that the asset should be handed over back to the liquidator, and the appellate tribunal also upheld the order. Now let us discuss a scenario that the intent of the legislature is that not many secured creditors should invoke section 52, because that complicates the process of liquidating a company. And therefore you see this regulation 21A and also this the NCLAT judgment titled as SBI versus Navjeet Singh. So all these are kind of deterrents for the secured creditors to invoke section 52 and decides not to relinquish in favor of the liquidation estate. So the first was that all these workman dues and the liquidation cost has to be paid. Second, the liquidator has to give a permission. The liquidator has to give a permission, and while giving permission, the liquidator can claim the liquidation cost, CIRP cost, whatever is pending recovery, and also the liquidator's fees. Now, then comes the regulation 21A that they have to sell the asset within a stipulated period. And there are two kind of regulations. One regulation which is applicable to those who are able to sell their assets under SARFAESI Act. So there is a different regulation for those who are covered under SARFAESI Act, means banks, some financial institutions, and some of the specified NBFCs. Now with this, in case you would see, in case the exclusive charge holder is not a bank, is also not a financial institution or any specified company by the RBI. So therefore, they would have to go through a different process of sale of asset even after invoking section 52, and they will have to match the price with the liquidator. So the intent of the legislature is that once the company is liquidated, there should be hurdles so that the creditors should relinquish their security interest in favor of the liquidation estate, and the liquidator should do all the effort and sell the assets rather than all the creditors separately. So, and there is another anomaly into this. When we talk about relinquishment, or when we talk about the exclusive charge holder, see, when we see section 52, it is very clear that it is not based on the type of facility or kind of collateral security. It talks about one secured creditor. So that is also being interpreted very clearly, that it is not possible for a secured creditor to relinquish some part of the security interest and to not relinquish some part of the security interest. For example, if a State Bank of India has given 4 kinds of loan to a company, one is the term loan, where the security interest is very clear, and the second is the working capital, where the security interest has been depleted, and the third is a car loan, where the security interest is apparently available in front of you, easily sellable, and then the fourth is loan against a property, where the property is also sellable and the property can also be realized very clearly. Now, this scenario, in case the law can be interpreted in such a manner that the State Bank can relinquish the security interest against the working capital, but not against the term loan or loan against property or car loan. But that's what is not permitted by the law, because Section 52 talks about a secured creditor may do this or may do that, but the secured creditor cannot choose the facility wise or security wise that they have to relinquish or not to relinquish. So this is a judgment like SBI versus Navjeet Singh and this Dhanalakshmi Bank Limited versus Technofab, a combination of these judgments and also the interpretation of Section 52, it becomes very, very difficult for the secured creditor to realize their security interests themselves under the SARFAESI Act. So on this particular judgment, if there is any question I can take up, we can take up the question at the end. I'll have just 1 or 2 more judgments.
So, sir, are you saying that suppose a secured creditor has only one asset?
Yes.
In my case, he has only one asset, which he
Right.
does not want to relinquish, which he wanted to realize himself.
Right.
That he can do, provided, as Madam Pooja Bahry has explained, he is willing to pay both the liquidation cost, which includes the liquidator.
Right. Right.
Am I right?
Absolutely. Absolutely.
Thank you.
However, in case any secured creditor who has 4 facilities and 4 kind of security interest, then in case he holds on to one asset, then all his remaining debt would become unsecured at 5th level of priority under Section 53. So that's what
secondly, you are saying as a liquidator, I'm not required to file the income tax return and get the books of accounts audited.
Yes, you are only supposed to prepare the books of accounts, prepare a receipt and payment account, get that receipt and payment account audited once in a year. That's the only requirement that the liquidator has to comply with.
Thank you.
Now, coming to this R. Velu, who is the chairman of monitoring committee and also the resolution professional for Palm Lagoon Backwaters Resort Private Limited versus Invent Asset Securitization and Reconstruction Private Limited. So this was a case where the concept of 330 days has been dealt with by NCLAT. Now, these financial creditors filed an application before NCLAT, NCLT Chennai, and later on it was transferred to Kochi Bank when the Kochi Bank started. And this R. Velu was appointed as IRP, and the tribunal held that the liquidation order must be passed considering that the time period of 330 days has elapsed and no successful resolution plan was passed during CIRP by the resolution professional. Now, this focus on 330 days, this is definitely a very, very important focus. Based on this focus, we also have a judgment called Abix Singapore Private Limited. It's a Supreme Court order, and which says that it is only and only in very special circumstances that the adjudicating authority should allow any extension beyond 330 days. So this part, in this particular judgment, the applicant filed an appeal before NCLAT requesting them to dispose of the order passed by the NCLT Kochi Bank. So the Kochi Bank, first of all, passed an order. The Kochi Bank bench of NCLT passed an order that since no resolution plan has been submitted to NCLT duly approved by the Committee of Creditor, therefore the company needs to be liquidated because there is no CIRP period beyond 330 days. So that particular order was challenged before appellate authority, and since this resolution plan was not passed within 330 days, the adjudicating authority must pass the order of liquidating as per the IBC. So this was the case. Now, it was also observed that any person other than the corporate debtor may make the application for liquidation order to the adjudicating authority. And the other thing it was held by NCLAT was that in case where maximum CIRP period, that's 330 days, has expired and the corporate debtor has failed to implement resolution plan, the liquidation order can be passed by adjudicating authority under section 33, read with section 60, subsection 5 of the IBC. Then it was also heard that the appellant was right in moving an application to the adjudicating authority requesting an order for liquidating the company, as the respondent did not rightly implement the resolution plan as mandated in the code. Now, this particular judgment, it's the basis. This judgment is the value judgment is September 21, and this was on 21st of September 21. This was unclear judgment. See, but then actually before this 21st of September 21, there was a judgment of ABIX Singapore Pte Limited versus Committee of Creditors of Educom. In the case of Educom, then this order from Supreme Court, this was on 13th of September 2021. So I mean that the basis of the order of ANCLAT may have some influence of the order of the Supreme Court in the case of ABIX Singapore Pte Limited. In the case of ABIX Singapore Pte Limited, it says that section 12 subsection 3 mandates the CIRP process, including legal proceedings, must be concluded within 330 days. This 330 days period can be extended only in exceptional circumstances if the process is at near conclusion and serves the objective of the IBC. So these two things, which are actually very, very important judgments. Now coming to the third one, which is in fact, I said the one which is Om Prakash Agarwal, the income tax part, that was argued by me. So this Nitin Jain, liquidator of PSL Limited versus Enforcement Directorate. Nitin Jain is my partner at AAA Insolvency. So he is, this case is being handled by us jointly in my capacity to supervise, and Nitin Jain is the liquidator in this case. So this, the company PSL, this was also one of the unique case where this liquidation as a going concern was approved by, the liquidation as a going concern was approved by NCLT Allahabad, no, NCLT Ahmedabad. And also it was mentioned in that order multiple times that liquidation as a going concern is akin to resolution plan. Is similar to resolution plan. So this was a case where the CIRP was the CIRP started in February 2019, and the RP was appointed. Then the liquidation application for the liquidation was accepted in 11th September 2021 because the resolution plan was not approved by the Committee of Creditors, and the RP was appointed as the liquidator. Now, after September 21, please watch the dates. After 11th of September 21, the liquidator received first summon from Enforcement Directorate under PMLA, and this some kind of a case was going on against this company since I believe 2014, much before the CIRP. Some case was going on, and then in January 21, someone was received from Enforcement Directorate to the liquidator, and they asked for some information. So we submitted the information. But see what happened in this. Then we received an email from Enforcement Directorate on 25th of January 21, and again someone on 27th January. So when they sent an email, in the email the ED wrote to the liquidator that you are requested not to sell the assets of the company because the investigations are going on and we might attach the assets of the company. Then based on that email, we filed a petition, writ petition before the Delhi High Court, and that was on March 21, and it was followed by an interim order on 17th March, and it was allowed by Delhi High Court to the liquidator that the liquidator can sell this company as a going concern, and there was the email which has been received from ED that should not disturb the liquidation process. Then like in April 21, on 9th April 21, this company was, the PSL was sold as a going concern to one Lucky Holding Private Limited for 425 crores. And as you know that the liquidation as a going concern is a concept which has to be approved by adjudicating authority, and an application was submitted to adjudicating authority Ahmedabad, and that application was approved and the sale was approved as a going concern by NCLT Ahmedabad. Now, this was approved in September 21, and in case you would see the timeline, and the liquidation was September 20, and the sale was approved by NCLT within 1 year, means September 21. And in this process, while we were waiting for the payment to come from Lucky Holding, while everything was set for handing over the company to Lucky Holding, the Lucky Holding also recruited some senior employees for running the company. Then we received a provisional attachment order under PMLA, and that was received on 2nd December 2021, where the assets of the corporate debtor was attached to the extent of 274 crores. And then immediately the liquidator moved the High Court, and the liquidator moved the High Court that in case I receive 425 crores, and the permission should be given to distribute that proceeds to the stakeholders. Now, in that writ petition before Delhi High Court, the section 32A was also argued, and then like how this argument went. I actually would like to tell you how this argument went. Now, under this, we have many involvements in those cases where the assets are attached by Enforcement Directorate under PMLA, and we have been keeping track of all the activities under this space. The creditors have given all the Nirav Modi companies cases to us for liquidating their assets. We are, as AAA Insolvency has been appointed as one of the partners of AAA Insolvency has been appointed as the liquidator for all companies of Nirav Modi, for all companies of Mehul Choksi, Gitanjali Gem Group, for all companies of Vikram Kothari, Kanpur-based Rotomac Group, the REI Agro, where all the assets are attached, the Varsana Ispat, where all the assets are attached, Diamond Power, where all the assets are attached, and the PSL, and many other cases where the assets are attached either by SEBI or. So we are keeping a kind of complete track on the PMLA cases. So there are three kinds of cases in the various stages of judicial forums. One cases are where the assets were attached before the commencement of CIRP. That's one category where the IBC is very weak. The second category is that where the assets were attached during CIRP or during liquidation, before the resolution plan is approved or before the asset is sold. And the third category is where this Bhushan Steel versus GSW is also there, and also in the PSL category, where either the resolution plan has been approved or the asset has been sold in liquidation process. So there are three categories of cases which are in judicial forums. Now we have lost the first and the second
So
many
in the
times.
second category, will the moratorium not apply?
Now, see, as far as the moratorium is concerned, I personally had gone to Supreme Court after completing the route of adjudicating authority and appellate authority and Supreme Court, and the Supreme Court held that the resolution professional cannot take the advantage of Section 14 during CIRP period against the criminal proceedings, because the PMLA is a criminal proceeding. So the Supreme Court held in that case. So therefore that we lost. So there are again two scenarios. One is before the insertion of Section 32 capital A to IBC, and one is the after this insertion of Section 32A capital A in the IBC. So when the 32A was inserted, I think this third category is pretty sure. The only thing that we have to prove that the resolution plan has been approved and the sale has been concluded. So therefore, however, in this case, PSL, it was very clear that the sale has been concluded, but still the Enforcement Directorate did the attachment. Although it might delay the process, but certainly we are very hopeful that in PSL, the assets would be detached in case the sale is considered to be as completely finalized. Now, see, when I talk about these three kind of cases, in some cases now, I think based on some central government directions to enforcement directorate, they have decided, and also in fact this the Advocate General of India has made a statement in Supreme Court that the enforcement directorate is releasing the assets. Those are mortgaged to public sector banks. So what happened? The enforcement directorate, in fact, passed an order. The special court under the special courts under PMLA passed an order that the assets of Nirav Modi Group and the assets of Mehul Choksi both should be released in favor of the secured creditors. In Nirav Modi, the stakeholders were public sector undertakings, and in the Mehul Choksi, in the Gitanjali Gem cases, the stakeholders were private sector banks. The enforcement directorate filed an appeal in the case of Mehul Choksi, Gitanjali Gem. However, they did not file an appeal in the case of Nirav Modi. So in the case of Nirav Modi, we are getting the assets deattached, we are getting the assets released from PMLA. However, in the case of Mehul Choksi, the appeal is filed by the enforcement directorate. So presently the law is not very clear. The appellate authority under PMLA is not existing for the last 24 months. Most of our matters are pending before Ahmedabad High Court, Kolkata High Court, Supreme Court, and also before the appellate authority under PMLA, and also before the special courts under PMLA. So most of the assets. So the only thing which has been successful so far is the release of the assets in the case of Nirav Modi, and that too not because of the judicial pronouncement, not because of the insertion of Section 32A, but because of the central government interference, so that the banks should not lose money, so that the banks should get their money, because it's also the same. Basically, the public sector banks are having the basically the same. It's the central government hands. So this presently, as far as the PSL is concerned, the I've already explained what ED is doing, what law says 32A, and what kind of judgments, what kind of judicial matters are pending before the various courts. So as 32A and all the three categories I have elaborated to you. So this is the various cases that I wanted to discuss with you. So there are certain other cases. In case you are interested, I would I can talk about some cases like the 62. I think there are certain cases regarding the workmen dues. This is a controversial issue. When we see this order, which is the Sawan Godiwala, the liquidator of Lanco Infratech Limited versus Mr. Rampala Siva Kumar, and this was February 2020 judgment, and this was a kind of a review of the ANCLAT's own judgment in the case of State Bank of India versus Moser Bear Karamchari Union, and that was in March 2019. From March 2019 to February 2020, and still I think some of the judgments are coming, some of the adjudicating authorities are still saying that if there are any provident fund, pension fund, or gratuity fund, if there are any provident fund, pension fund, or gratuity fund, and that would remain outside the liquidation estate under Section 36, subsection 4, clause A3, and it will remain outside the liquidation estate. It was held in that manner by Justice Mukhe Paudar Saab in such a manner that it was being interpreted that even if there is no money available in provident fund, pension fund, or gratuity fund, it is the duty of the liquidator to fill that money in these funds, and all that money which is due in regards to provident fund, pension fund, and gratuity fund should be paid even before the liquidation cost is paid, or even the CIRP cost is paid, or even before the secured creditors are paid. That was the interpretation which was being done for SBI versus Moser Bear. Now, in this case, this Sawan Godiwala, and this was the judgment written by Justice VP Singh, and it was held in this case it was held that the provident fund, pension fund, and gratuity fund do not come within the purview of liquidation estate for the purpose of distribution of asset under section 53 of the code. Based on this, the only interference which can be drawn is that pension fund, gratuity fund, and provident fund cannot be utilized, attached, or distributed by the liquidator to satisfy the claim of the other one. So it means that if there is any fund, it refers to those cases where these funds are being maintained, by some companies, whether within the same balance sheet or outside the balance sheet. Some companies do maintain funds which are called pension fund, gratuity fund, or provident fund. Now, the only meant what exactly section 36 subsection 4 was meant is that these funds would not be used for any other distribution. These funds are exclusively for provident fund, gratuity fund, and the pension fund. In this case, in case where is no fund is created by a company in violation of statutory provisions of section 4 of the Payment of Gratuity Act, then in that situation also the liquidator cannot be directed. The liquidator cannot be directed to make the payment of gratuity to the employees. See, this is the heading. In case there is no availability of fund in these three funds, then it is not the responsibility of the liquidator to. It is not the responsibility of the liquidator to fill the fund into these funds and then use it. That is something which is not really required. So it is this particular judgment of Sawan Godiwala is also pending before Supreme Court, and the final adjudication will definitely be awaited. So this is another judgment which is very, very important with regard to the workman dues. Now, I also would like to take you to one scenario, which is the section 53, how the distribution would be done. So if I just try to, I'll just try to section 53. If you just see, this is what is section 53 presently. Now, when section 53, when we talk about this, the CIRP cost and then secured debt. Now, in the case of Technology Development Board versus Anil Goel, which is me, an order was passed by NCLT Ahmedabad that the way the distribution has been done by the liquidator, it is absolutely fine. No, the distribution was done based on the Insolvency Law Committee report dated 26th of March 2018, and in paragraph number 21.1 to paragraph number 21.6 of that report, it has been clarified that while distributing the proceeds of assets to secured creditors, the liquidator will consider the priority of charges and also the value of security interest. And that particular opinion in the Insolvency Law Committee was because of the very old judgment of Supreme Court in the case of Sidco Leather versus ICICI Bank. And that was a judgment in 2005. That was a judgment passed under the Companies Act 1956, where the language used is almost similar to section 53. Now, that particular order, Technology Development Board versus Anil Goel, was challenged. That was the corporate debtor in that case was Gujarat Oleo. That particular order was challenged by the Technology Development Board to Appellate Authority. Appellate Authority found that they could not in fact find any two categories in section 53, and they said, and you can see the section 53, they were saying that in case we read carefully, the following debt shall rank equally between and amongst the following. One is the workman dues for a period of 24 months. Then it is written debt owed to a secured creditor in the event such secured creditor has relinquished security in the manner set out in section 52. Now, Anclet said that he could not find any other category which is for first charge holder, second charge holder, subservient charge holder, and also could not find anything that the distribution would be done based on the value of the security interest. Therefore, he said that in case anyone would like to, anyone who has an exclusive charge will invoke section 52. All others will relinquish in favor of the liquidation estate, and the liquidator will realize all the assets and will distribute in the proportion of the claim of the creditor. That was the judgment given by ANCLAD. Immediately it was appealed against by Kotak Mahindra Bank, which was not even a party to this case, but they filed a case before the Supreme Court, and the Supreme Court, presently the status is that the Supreme Court has stayed the judgment of ANCLAD. So we are waiting for this judgment also, how this judgment finally can see the light of the day. So this is another important scenario which is pending. This is another important scenario which is pending before the Supreme Court. Now, one more scenario that I want to discuss is that Shubh Kamna Build Tech. In that case, the Noida Authority and Greater Noida Authority was held as an operational creditor. It was argued based on the accounting standard, because the accounting standard pertaining to the operational leases and financial leases. So in fact, that was also case of AAA insolvency. So we argued that the Noida Authority or Greater Noida Authority's lease agreement is just like an operational lease. It is not a financial lease. So if it is an operational lease, so they are operational creditors. So the adjudicating authority passed an order in our favor, and the appellate authority also passed an order in our favor. They held that the Noida Authority and Greater Noida Authority, they have given a lease of the land, and the land can revert back, and it is not for fulfilling all the conditions of financial lease. Therefore, they are the operational creditors, and that matter is also pending before Supreme Court. So what is presently the Supreme Court is sitting is one, how this section 32 capital A would work in the cases of three scenarios of attachment by ED. Second, in the case of distribution, how the section 53 will deal with the various creditors having different priority of interest and different security interest. And then as far as this landowners are concerned, what are the rights of the landowner? What are the rights of landowner? And fourth is how the workman dues and how the section 36 subsection 4, the provident fund, pension fund, and the gratuity fund would be dealt with. So these are some of the issues which are pending before Supreme Court. And I think we now, like Pooja and myself, will take up some questions in case there are. So I tried to highlight some of the issues which are pending, and also we would be able to answer the practical part of it in case there are any questions.
Sir, my question is that, hello.
Yes, please.
Yes.
My question is that there is.
I would request everyone that before asking the question, they should also mention that you are expecting your answer from me or from Pooja ji.
No, from you, sir.
Okay.
My actually, yeah, I see so many cases you have explained very well. And my question is that if you see the IBC and we are discuss the tax provision on Income Tax Act, so there in Schedule 3 there is of IB, there is some 11 schedule is there, and income tax and so many act is government amended for the benefit of this IBC. So government can also do that if there is something problem is coming in the for IBC process, so then they can amend immediately like that. There is 90%. If the COC approve that we can take the application with back like that.
Now, this is what government should do and what the judicial authority should do. This matter would be controversial, In fact, I delivered a couple of lectures to National Law University, where Dr. Sahu, who has joined National Law University as a distinguished professor, so he invited me for delivering some lectures. So when all the students were asking why the government is not making law when all these matters are pending before Supreme Court or various other high courts, so the answer the Dr. Sahu gave was not everything has to come from Parliament. Most of these situations should be adjudicated by the Supreme Court or High Courts, because see, like, no law can be made where all kinds of eventualities are taken care of. So different, the law is only to showcase the intent of the legislature, and then the Supreme Court has to deal with, or the High Courts have to deal with the different scenarios. So that was the answer which was given by Dr. Sahu. So I can say the same thing, that not everything should come from Parliament. The adjudication is also a very great process. And in fact, adjudication and legislation and the practice, these three things finally makes the law. And that's what is being done also in this case.
But the second question is, if you see the Article 13 and sub-article 1 and Article 13 of the Constitution of India and sub-article 2, that is telling about the doctrine of eclipse, 13 sub-article 1. If there is a all act is there before the independence, that it will be the doctrine of eclipse will be applicable. If there is a problem, if it is not according to the constitution, and there are some basic structure is violating in the earlier law, so it will be doctrine eclipse. And second thing, so and this article 10, the same thing it will be in IBC law. So government is looking for the so many amounts, and they say that there are so many cases the company is running like that and making fraudulent, and after some time they run away. So the government gives some scope and power, because there are so many cases pending 2 years, 3 years. Some application is pending for more than 2 years. So
I think,
Anilji,
I could understand. I think some kind of relaxation should be given to the judicial system of this country because of the pandemic, and because the capacities were low and the working in the judicial authorities were low. So maybe we are feeling that some of the matters are pending, but yes, this is the process in most of the countries. In our country also the same process is repeated, and we agree, yes, it can be improved. And wherever we find a forum, we also say the same thing as you are saying, that there are many things which are actually pending for some decisions, and the government should do something. I think the message is very clear that you are trying to give, and we all agree to this. And wherever we find any forum, we would also communicate the same way.
Yes, sir. Thank you. Thank you, sir.
So, Pooja ji, there are many certain issues which are kind of unresolved in liquidation process.
Yes,
maybe
sir.
that you can also take up some of the unresolved issues.
Right.
Maybe there are now in some cases that we are facing whether the liquidator can permit withdrawal of the claims. In some of our cases, Pooja, what happened is that since the stakeholders found after submitting the claim that there is no asset in the company, so they were scared of contribution, so they asked us to, we are withdrawing the claim. Then we looked at section, I think 38 subsection 7, that there is no power with the liquidator. The only thing that somebody can modify or withdraw a claim is within 15 days of the submission of the claim. After that, there is no possibility that somebody can withdraw the claim and can run away from the process. So these are some kind of other cases which are very important, and I think we can also look into whether
in fact, we can, I think we have about 10-15 minutes. So I can primarily discuss about 3-4 challenges, which I do feel as liquidators, which practically, which we have felt, and I have, which are again the unresolved issues, and wherein I've had the opportunity to meet the new chairman of IBBI and raise these points also in front of them, that these are the challenges which need to be looked at, and you know, whether what are the challenges, whether it is regarding in a liquidator, liquidator needs to keep records for a period of 8 years for even after a dissolution has happened. But at what place is he going to be keeping those? Who is going to pay the rent for this? So some specific provisions in the code which are needed, primarily that, regarding where a centralized place where these records can be maintained, and some amendment can be made in the code. Then again, of course, you have very eloquently discussed the issues with reference to, attachments by EDs, EPF. I myself am, stuck in cases where the CBI investigations are going on, and I, as a liquidator, have to regularly visit the office of the CBI. Every day, new summons are coming, warrants are coming, wherein the data needs to be provided. And as a liquidator, it is our duty to enforce and to ensure that the data is provided. But practically the challenges which are there. So somewhere or the other, the code, I mean, when Sanil was saying that there are various issues which can get sorted, very quickly, but it's, it has taken 5 years for a lot of issues to get resolved. A lot of jurisprudence has been formed. And yes, there are issues also with reference to, and in fact, I'm looking forward to if there is any judgment which comes on regulation 37A. I think you all would be aware that, assignment of NRREs is something, the regulation has come in regarding, the NRREs is possible when there are not readily realizable assets. Then the liquidator can actually, sell those assets. But at what value is a liquidator going to sell those assets? There are genuine issues. There are certain, we need to address that there needs to be a detailed procedures which can be adopted by a liquidator, so that the liquidator is not questioned later on. I mean, that is what my viewpoint is, that there are cases when, as a liquidator, we want to sell assets, when there are debtors, there are loans or advances which are valued at nil value. But then who is firstly going to buy those assets? Of course, they say that the market will be formed and those assets can be sold. But then what should be the valuation that the liquidator should put on selling those assets? And if there are any ongoing investigations, with various departments and various underlying these avoidance proceedings, so who is going to assist the department once you've actually sold these NRRs? So if any kind of detailed procedure can be implemented.
So I think I can add something over here.
Yes.
So when we tried to sell our assets like NRRA, when we tried to sell this not readily realizable assets under regulation 37 capital A, and we prepared an agreement, also assignment agreement, and also the stakeholders were agreeable that they would be okay in case the money is given to us on realization, and then the buyer will keep some fee out of this realization. However, the only issue which came was how this assignment would be done in a valid manner. The stamp duty is huge. Who is going to invest in stamp duty? Because see, when we take assignment under SARFAESI Act, there was a special amendment which was made that any assignment under SARFAESI Act would not attract stamp duty, or the stamp duty was concessional, maybe about 10,000 rupees only. Now, in this case, like the stamp duty is not amended, and in case we try to assign, maybe that the consideration is future consideration, and nobody knows the future consideration, so the stamp duty would be leviable on the book value. So if I have a sundry debtors of 16 crores, then I want to see kind of sell it as NRRA, then how much stamp duty? In fact, a couple of transactions were held up only because of the legality of the transaction, because of the payment of stamp duty. This is one which has to be handled by the government immediately. And the second issue which is coming to most of the liquidators is that there are all kinds of litigation which starts when the liquidation commences. Now, the liquidator is also supposed to recover money from the debtors, advances, also arbitration, arbitration, and also kind of various other assets. Now, in case I have to recover the debtors, then I am not finding the adjudicating authority, and the adjudicating authority is saying that this is not under my jurisdiction. You can't bring everything to adjudicating authority. In case we read section 60 subsection 3 and 5, it is very clear that anything pertaining to liquidation, it will go to the adjudicating authority. However, there is a concept of private law and the public law. So whenever there is a public law, that means that the public law means that wherever the separate adjudicating structure has been made by Government of India, maybe Income Tax Department, Customs Department, Service Tax Department, where the separate adjudicating structure has been made. So that is something where the public law that cannot come to NCLT. However, for other things, for recovery, I should not go to commercial court, I should not go to recovery courts, I should not go to high courts, I should go to NCLT only. Similarly, for getting the property handed over, like getting it vacated from tenants, that also should not go to rent control. See, otherwise the liquidator is forced to go from court to court and from pillar to pillar and to different judicial authorities. So the liquidation process will never close. NRRA is not successful. The adjudicating authority is declining to entertain my applications where I have some recovery from government department. I have some recovery against the land sale. I have some recovery from the, I have to go to Income Tax Department. I have to go to GST Department for various refunds. So that's something which is, once a liquidation case starts, it will never end. So that scenario is a disturbing scenario where something is to be done. Something needs to be done for the liquidators so that the liquidation of the companies should start as early as possible. So it should conclude. So this is these are some of the pending issues that I find. Pooja can add some more. This is only
there are many pending issues. I think if I start on challenges, I think that's one session which I have given almost at least I think 10-15 times in the past 6 months, that what are the challenges faced by liquidators. And as yes, as a challenge, we need to close down various issues, is also with respect to liquidation fees when there are no assets. So there are cases, and I do know of a lot of liquidators wherein, it is being given in the regulations that, yes, there's a regulation 39D where the COC decides the fees of the liquidator. And there is also a regulation 4. But that regulation 4 is on the percentage of the amount recovered and amount realized. So what happens if there is no realization? What happens when the only assets which are actually, are not relinquished firstly by the secured creditor, and also the fees is not decided as per regulation 39D. So that is happening a lot of cases wherein the NCLT is directly appointing the liquidators. I do know a lot of people. So we've been stuck in cases where, yes, it is given, there is a regulation of contribution to make liquidate, to pay that liquidation cost. But when there are no assets, so now hopefully we have a judgment as of date today where this can be helped. Up till now, there was not a judgment, wherein Mr. Navjeet Singh's judgment is very, very important, especially where, a secured creditor up till now who was realizing outside was not paying the liquidators fees. And now I think there is some kind of hope for such liquidators to get fees on distribution of the same. So when we were discussing also, I would like to relook on that case which Mr. Goel discussed about that Mr. R. Velu for the chairman of the monitoring committee. So that when Mr. Velu, as a chairman of the monitoring committee, had filed an application for liquidation, wherein the resolution plan was not implemented by the successful resolution applicant. In this, one very important matter has actually been closed, which is with reference to when, we have four points that when can a liquidation order be passed. One is when the COC, when the plan is not received or the COC decides. So one of the options in that is when anyone, when it is the resolution plan is approved, but is contravened by the corporate debtor, then anyone other than any other one who's prejudiced by such contravention, is affected by this contravention, can make an application for liquidation. So this particular order of the monitoring committee, wherein Invent ARC was the successful resolution applicant, and they could not implement the plan, of course, in 330 days, but due to a genuine reason, even if it was due to a genuine reason, but because they said that the RBI rejected their UARC plan. So that's the reason they could not implement the plan. For whatever may have been the reason, they asked for the refund of their performance guarantee amount. And then the court has specifically mentioned that no, that if a plan is contravened by a successful resolution applicant, then in that case, the the NCLT had said that they do not have the powers to pass an order of liquidation. And whereas then finally, NCLAT, gave them, passed an order saying that yes, the NCLT did have the powers to pass an order of liquidation when any non-compliance has been done by the successful resolution applicant. Though they did not pass any orders on, in that case, the liquidator had forfeited the initial EMD amount, and then the NCLAT did not pass any orders on that. But then, yes, this is one of the first orders which has actually come that if anyone has contravened a successful resolution plan, then anyone other than the corporate debtor can file an application for liquidation, and the liquidation has been allowed in this particular matter. So this is when you're talking about this Mr. Velu's past judgment. So this is particularly with reference to a plan being approved, not being implemented, and then an order of liquidation being passed.
I think we can seek some questions from the participants.
Yes, please.
Yeah, Pooja ma'am, this is for you only.
Yes, sir.
Navjeet Singh versus SBI matter, where
Yes, sir.
It has been held that secured lender, even
Yes,
if
sir.
he doesn't relinquish his security interest, still he will be required to pay the liquidator's fee.
Yes, sir.
In this case, what happens, if the secured lender is not relinquishing the security interest, the
Right.
money doesn't come to the corporate debtor. It doesn't come to liquidation account. It's taken by the secured lender, and even he, utilizes it towards his dues. So that means even the distribution part, which is regulation 4 table, which the liquidator is on realization and distribution. Then how do you meet the requirement of regulation 4, assuming that the COC had not decided the liquidator's fee? So how
if assuming what my understanding of this entire thing, when I was even I was reading this particular order of the NCLT and NCLAT, so I was saying, how is it going to be implemented? So when we on your screen, I'm sure like you can see the regulation. So here I feel one was on the amount realized and then was on the amount distributed. So as per my understanding of this particular order, I do not feel that he would be getting a fees on the amount realized, but he should be getting it as amount distributed, because it is particularly mentioned in the order. So when you see the order, it is mentioned that it is clear that firstly that they have clarified that the secured creditor, even when he is realizing its own security, he has to pay the fees. They have clarified that two clarities have actually come from this order. One clarity which has come is that the liquidation cost would include liquidators' fees, because what they were mentioning, what they had said in court was that yes, we are ready to pay the liquidation costs, but not the fee claimed. And they also said that that the secured creditor is liable to pay only the liquidator. So, but they primarily said that he is not entitled to the said fees, but the order which has come that when the liquidator distributes which is not realized, so in a way they have given the clarity that yes, the liquidator is distributing any amount which is not realized by him, he will be entitled to fees corresponding to the amount distributed by him. So as per my understanding, the amount what they have got would be their distribution. So as per my understanding, I think as per regulation 4, they in this matter should be eligible as per to the percentage on the amount which is distributed to stakeholders. That is what has been declared.
But ma'am, assuming that you are saying that, okay, he will not claim anything on realized amount. He will claim only on distribution.
No, I'm not saying, I said it is my understanding with seeing both these orders. I read the NCLAT order and the NCLT order, they both simultaneously, which I put on your screen also to read. So I think
I have understood. I have understood your point. But the point is, man, the money is not coming in the...
Is not coming to him. But when the NCLAT gives an order like this, sir, they will have to give the details of the amount, and then I think the liquidator will decide that this is the, as per the regulations, this should be my fees. And hopefully the liquidator should get, I think this order is only about 4 days old. So I think we should be asking Mr. Navjeet Singh very soon that, did the bank clear, his fees or not. But as per the order, as per my understanding, what they say is that, because the clarity has been given that, but NCLT had not said anything, that NCLT had given very specific directions. Please make the liquidators fees pay as per the regulations. They quoted the regulations. They quoted regulation 2A, the regulation 2A, 21A and 37. They just quoted it. And they said that even, and the liquidator had submitted that yes, the securities are out of the liquidation process, but we feel that he is liable to pay the fees as per regulation 21A. So as per my understanding, sir, because it has been very specifically given in the code, in the order, that yes, if the liquidator distributes any amount which is not realized by him, he shall be entitled to a fees corresponding to the amount distributed by him. So I assume that because it is not realized, but will be distributed in a way because he's giving it to the secured creditor, then he should get that fee. So that is my understanding. Mr. Goel, what is your understanding?
It is not, money is not going out from
I think we can.
No, but the secured creditor getting that amount is distribution to him, sir.
No, it's like Pooja, my understanding is that once we talk about liquidation fee as per regulation 4, in the absence of any specific fee decided by the COC, then we talk about the distribution and realization both. See what happens in the case of, in case a secured creditor sells the asset and also distribute the money to itself.
Yes.
So that means the realization as well as distribution both has happened, but both has not taken the dip into the liquidation account of the liquidator. However, both the things have happened. The realizations have also happened and the distributions have also happened without taking a dip into the liquidation account. Everything else has happened. So therefore, when we talk about liquidator's fee, the liquidator fee means as per regulation 4, which also includes distribution and realization.
That I totally agree with you, sir. I totally agree with you that otherwise in normal scenarios, it of course, if there's a liquidator fees, he is entitled to amount, which is of course on what is amount realized and of course what is it is distributed. That is the reason the clarity had also come. If you can see on your screen, the amendment which had come that where a liquidator realizes does not distribute it, he will be eligible for a fees corresponding to the amount realized by him. Because I believe in this case, wherein this amendment had come, it had come because of there was a matter wherein there were two liquidators, where one liquidator had realized the amount, the other liquidator had distributed it. So there was some kind of differentiation that who should get what. So that is the reason the regulations were amended to say, where.
In some of the cases, like when the RP left the company, when the RP left the company, there was some money which was lying in the bank account, and that was like simple amount lying in the bank account. So the creditors challenged why this liquidator would claim fee on the this amount, because this is not something which is considered to be realization. So I also feel that the money which is lying in clear bank account, it should not be considered as
it should not be considered as I also agree with you. I also agree with you.
Whereas in one case where the income tax refund was passed before the liquidation starts. However, the check came after 3 months, so that was held by the adjudicating authority that the liquidator has realized this money. So he is also entitled to his fee on realization as well as on distribution.
No, but one order had also come similarly in an income tax order where it just stated that all he has done is send some letters and to the income tax department, and he should only get the cost and not get the fees on the liquidator when an income tax refund has come. So there are, like I said, many matters where there are contradictory judgments. So when we talk about judgments, I think somewhere or the other, as a liquidator or an RP, if I pick up any one topic, I can pick out 4 judgments, which is one against the matter and 4 judgments, which are, for that matter. So we are just hoping that almost all the issues should be sorted as soon as possible. That is what we as liquidators, IPs hope. And that is our only hope, just so that we are able to fulfill our duties in the right spirit of the code and the laws.
I think the time is also almost up.
Yeah.
We can even
so shall we conclude, or there's any other question?
I think in the meantime, you can stop sharing it. We can see some of the faces.
Sir, if nobody's asking,
Participants can ask the questions if they have.
Sir. Can I ask one question for Anil, sir?
Yes, Mishraji.
Sir, this is
Yes,
regarding
sir, please go ahead.
liquidation in real estate projects. Like, you have regulation 32E and 32F, where, sale by a business or sale by a going concern. Now, in case of real estate, there are various projects which goes.
Yeah.
Can we treat each project as a business, sale as a business, and treat it as a sale as a business?
No, certainly, why not? They see, like, each project can be considered as a business, not as a corporate debtor, as a going concern, but the business as a going concern. You can definitely treat one project as a business as a going concern. So the only difficulty in the real estate cases is,
yes,
how do we consider this the obligation of specific performance on the corporate debtor that is committed to the allottees, because the allottees they do have a right of specific performance, and the bankers, they have a right to take over the properties and sell under SARFAESI Act. So out of these two, which would prevail? Who would have the priority? Because see, like, when we see this section 331 of the IBC, the definition of security interest includes the I think this is an important subject. Pooja, if you don't mind, should we spend 1 minute on this?
Yes, sir, please.
Yes, I think we should. Yes, we should.
This is very actually important. Like, I will actually take you to okay. Yes, I will just have to take it to. So this, I am only trying to see this section 331. Now, first of all, section 330, secured creditors, means a creditor in favor of whom a security interest is created. And now, in case we see the definition of security interest, means right, title, or interest, or a claim to property created in favor of or provided for a secured creditor by a transaction which secures payment, or the first is the any transaction which secures payment or performance of an obligation. So when we see this performance of an obligation, it actually shows that if I sell my property, now I'm taking an example, that if I sell my property before CIRP, enter into an agreement to sell as a corporate debtor, I can enter into an agreement to sell. I'm selling my factory to another person. I have taken 50% advance and I have entered into an agreement to sell. Now that person has given, for example, as an illustration, 5 crores of rupees to corporate debtor. Now he will file a claim. He will file a claim because he have a right. He have a right of performance of an obligation under section 53 capital A of Transfer of Properties Act. And then in case we read, and includes mortgage, charge, hypothecation, assignment, and encumbrance, or any other agreement any other agreement or arrangement securing payment, or again, performance of any obligation. Performance of any obligation. Try to understand what I'm trying to say, that this is a case of allotee.
Yes.
This is a case of a person who has entered into an agreement to buy a property. That person has a right, has a security interest as performance of an obligation. This is what somebody needs to argue and take an order, so that all these people who have given advance for buying a property of the company, which is under CIRP or under liquidation, they should be considered as secured creditor. This is what is my case. And when we actually go again, we get to see section 33, and it also defines transaction, because the transaction word is here, and the transaction is again defined, includes an agreement or arrangement in writing for transfer of assets or funds. Take the linkage. Here it is transaction. Here the transaction is defined. It includes an agreement or arrangement. I'm talking about the builder-buyer agreement, or I'm talking about the agreement to sell. And it also defines the transfer, includes sale, purchase, exchange, mortgage, pledge, gift, loan, or any other form of transfer of right, title, possession, or lien. Similarly, transfer of property means transfer of any property, and includes transfer of any interest in the property and creation of any charge upon that property. If we all taken together, section 3, subsection 31, starting from 30, 31, 33, 34, and 35 taken together, it makes a case that the home buyers, they have a right of specific performance, so they have a security interest, so they should be considered as secured creditor. So when the liquidation comes, in the case of liquidation, there are two parties now, they have security interest. One is the bankers and the other is the home buyers. So this is something that this is something which has to be dealt with by, because there is no court which actually is gathering that courage to make home buyers as secured creditor, because that might even disturb the entire real estate industry in the country. However, the law has been made in such a manner, because if, let us not consider home buyer, let us consider a standalone person who has purchased a property of a company. What is he? Is he unsecured? Like that means that any person who actually, he has purchased a property, just because the insolvency has started, he will lose his money. No. That's what I'm trying to say, because as far as this real estate cases are concerned, very, very sensitive.
So are you saying that all these home buyers should be treated as secure lenders? This
is what I'm saying. This I've already shown it to you. This is what, and when we see this, see, Pooja also knows it. What is the definition of security interest under SARFAESI Act? It is not like this. This word of specific performance is not there. We have the definition of security interest in SARFAESI Act also. Yes. But that definition is different. This definition is different, because it was trying to capture an event where the asset has been sold before the CIRP to protect the interest of that purchaser.
But as on date, I don't think there is any judgment which you can use to say that they are secure.
I'm only trying to say that anyone can guide their advocate.
They can. Yes, they can. But as on date, there isn't any judgment wherein you can clearly say that they are secured financial creditors. And also when anyone is like, when Mr. Goel was saying, can sell any asset just prior to maybe CIRP to a third party, that does he become a secured creditor or not? But also once a CIRP commences, we also need to keep in mind the PUFE transactions, which is whether that particular, was created, whether it was a preferential transaction, whether it was an undervalued transaction. That's something which the RP would see. So that is also needs to be considered. Was that avoidance transaction, or was that a genuine transaction which had just occurred just before prior to CIRP? So there are in fact, there are various issues. If we start talking only about challenges, today we are discussing case laws, but then there are challenges and various, gray areas, which we hope to close very soon. So that was my take on it. And any other questions, sir?
I think we can go to now Radhika to close the webinar now.
Yes, sir. I hope all the participants don't have any further questions. So we'll end up the session. On behalf of ICICI IIP, I thank you both the speakers, Mr. Anil Goel sir and Ms. Pooja Bahry ma'am, for taking up time and discussing the case laws. It was a very good session and a wonderful session. Thank you so much, sir and ma'am. Thank you.
Thank you so much.
Thank you,
Thank you for the
ICSI,
privilege.
for providing this opportunity. Thank you all the participants for remaining connected to us. And I have seen today wonderfully the number of participants was not dipping.
Yes.
It remained constant, Pooja. It's
Yes.
like thanks to you and thanks to me, because they were in.
It was a wonderful opportunity to interact with everyone, and we hope we all find all the answers very soon, all of us, and you're able to close the issues. Thank you so much.
Thank you very much. Thanks a lot. Thank you.